Secretary, please call the roll.
Mr. Broll,
Present.
Mr. Lalonde,
Here.
Mr. Jakubiec,
Here.
Mr. DeHunt,
Here.
Ms. Julinski here, Mr. Palazzolo,
Here.
Chairman Lubeck.
Here. Brings us to the approval of the agenda. Is there a motion?
Yeah, I'd like to make a motion that we approve the agenda as written.
Support.
We have a motion to approve as written with support.
Mr.
Any
Chair,
comment?
I'd like to make just a suggestion. After the lengthiness of our last meeting, I really don't want to be here until that type of time frame. So can we all agree to some sort of a hard stop at some point? So we're not here until the wee hours of the morning? Because let's face it, we can get lost in the weeds on the simplest things. So if we could do a hard stop at some point, and if we finish, great. If we don't, then we take it up.
Did you have a time in mind?
I don't want to be here past 10 o'clock at night. If somebody wants to go a little later or earlier, I'd be open to the discussion, but at 10 o'clock, party's over. Your thoughts?
Commissioners?
Well, I agree with that. I don't know if you need a motion or just a agreement among us.
I'm looking for consensus rather than a motion.
Okay. I can go with that. I was gonna say 9:30.
I like Leo's idea better.
Yeah,
9:30.
I'm thinking earlier than that,
I'll
but
agree.
I'm good.
Okay, we have 9:30. Do we have 9:15? 9:15, 9:15.
Sold America.
Okay, so the commission is in agreement that we're looking to wrap this thing up this evening, whether we're finished with our work or not at 9:30. Okay, Secretary, please call the roll on the approval of the agenda.
Mr. Jakubiec,
Yes.
Mr. Lalonde,
Yes.
Mr. Broll,
Yes.
Mr. DeHunt,
Yes.
Ms. Julinski, yes, Mr. Palazzolo,
Yes.
Chairman Lubeck.
Yes. That brings us to the first hearing of the public. Anybody that would like to be heard may do so. Please approach the podium, state your name, and also print your name on the notepad that is there, so
Can
we
we
can
get some lights?
properly reflect that in in our records.
Commissioners, my name is Daniel Curris. Been a resident here for 26. I've been in business in the city for almost 40 years. I sat on the first DDA here when it was created, and I just want to bring what the DDA was created for with the tax increase in the DDA. I'm not sure if everybody knows the TIF money. So any taxes that were created in the Downtown Development Authority got to be reinvested in the downtown of East Point. And with issues like this that are coming up, I think we're totally missing the boat when we keep anything zone B2, which is DDA property, out of the running for these dispensaries. If we include B2, take the Big Boy for instance, which I've owned for almost 40 years, it's for sale for about $500,000 right now. I can get on the better side of approximately 900 to $1 million if I sell it to a dispensary. That increases the taxes just on that piece about $250,000 over the 10 years, not including any of the support businesses that are going to come in to the DDA if this is allowed. We're looking at approximately $1 million plus to keep in the DDA, in the Downtown Development Authority with TIF money. And I just want to bring it up so it's not overlooked, and I'd like to see the DDA included, even if it's one of the 3 licenses that we have, so we keep that money in our downtown. And we can do what we want with that money and make our downtown very, very nice. Thank you for your time, and I appreciate it.
Anyone else wishing to be heard? Yes, sir.
Commissioners, Gary Myron from East Point. My concern is the border. Dispensaries from other cities, like Roseville and Warren, is having an issue. Because Warren wants to put one in, and Roseville is right on the border there. I don't know if we need something where, say, if Warren puts something right on the border of East Point, if Roseville puts something right on the border, do we have something to say? Or do we have somewhere to say, well, you can't do that because you're too close to residential? And about what the gentleman was mentioning earlier about big boys, there's going to be a lot of traffic. Do we want a lot of traffic down there? Because there's nowhere else around here. I know the other ones that are not recreational, just medical, and there is a lot of traffic. And it will create traffic because there's nothing close by this area. So we have to watch that too and make sure the traffic and the parking lot is big enough. And that's all. Thank you.
Thank you. Anyone else wishing to be heard? Anyone else wishing to be heard? Anyone else? Seeing none, we will close the first hearing of the public. We'll move on to approval of minutes. There are no minutes to approve tonight, so we will move on to unfinished business, which is the medical marijuana draft ordinance. When we adjourned last week, we had some questions. Mr. Albright, the primary questions were the section that we are delving into. Seems like a lot of those requirements would be handled already by the state of Michigan licensing requirements. So if they came to us pre-qualified, we really probably don't need to have a lot of this in our ordinance.
But if the city chose to require those different items, the city could. There's a, the section is MCL 333.27402, which governs license issuance under the Medical Marijuana Facilities Licensing Act by the state. And it does talk about different criteria such as misdemeanor, felony or misdemeanor convictions, that kind of thing. So it goes into those various items which the current proposed ordinance also discusses. So again, if the Planning Commission wants to take a look at that or the statute and compare it with what is before it, the Planning Commission can certainly do that, or they can the Planning Commission can just leave it alone, and knowing that, yeah, the state does require it on its end, but the city is also going to require it at this level. We could do that.
So if we put something in there that's not necessarily set with the state, whatever it is, do we run the risk of being sued by somebody because the state of Michigan hasn't?
Well, this particular section that's before the Planning Commission this evening comes from an ordinance that is already on the books in a neighboring community.
Okay.
So these are this was just taken directly from another ordinance.
I guess my only concern is I just don't want to, nothing against your profession, but we don't need to make the attorneys in this industry even wealthier through litigation. So I guess that's why I'm looking to be as circumspect on this whole thing and narrowed views and all that, just to make sure we are safe, because we don't need to see anything blow up in our face.
Well, the section that's before the commission this evening, as I indicated, is an ordinance that is been in effect in other communities, and as far as I know, those communities have not been the subject of any litigation.
Okay, thank you.
What was the Michigan code number? Can you repeat that, please?
333.2, and then it go 207, 208, 209, it goes on. The administrative rules.
Thank you.
Mr. Kroll, if you want to take a look at that, I have a
Yeah,
copy.
that'd be great. Thank you.
So if I remember correctly, we stopped at the top of page 11.
We actually, we were able to get through section 4, factors considered for granting permit, according to my notes. We were able to get through subsection A2.
Yeah, they four.
We started talking about
Did we make it? I didn't think we made it through that section.
Rich. Thank you.
Well, I do have a note on here that we had changed the language about the insurance pending a risk management review.
That's correct. There was some discussion about the other sections, but the last change I had was under 2, it reads the financial ability of the applicant to purchase and maintain adequate liability and casualty insurance, and it was agreed to remove the words adequate and casualty and just have it say the financial ability of the applicant to purchase and maintain liability insurance, period.
Did we decide to keep one? I thought we had talked about removing it.
Well, on page 9, there's a definition as to how much liability insurance is required. So I think that's where, I believe that's where this particular statement is referencing, okay, it's already required based on page 9, so we're just saying you have to maintain that coverage.
It's the financial ability to maintain coverage. Right.
Right. Page 9.
242. Somebody does have to remind me, did we agree to keep one, or did we want to remove one? I had a note that says we wanted to remove it.
I thought we were going to remove that too because it was too ambiguous.
Yeah.
I think there was some discussion, but I don't think there was a decision because I don't have anything with an X through that language.
How do you determine moral character? I mean, that's morality is kind of a viewpoint in people's opinions these days. Or,
Yeah, it's vague and duplicative in my mind. I mean, financial ability, business experience, that's, I think, covered in other sections. The integrity, moral character, and reputation questions are rabbit holes I don't want to get, I wouldn't want to be on the committee to evaluate that.
I'm in complete agreement with that.
Any other thoughts from the commissioners?
On 4.1,
4A1.
I agree, it's fine.
So there's agreement to remove
Yeah.
4A1.
The whole thing?
Yeah.
Yeah, the whole thing.
I'd like to look at item 11 under 4A. The applicant's business plan, oops, sorry.
Do you mind if we go in order? So we don't, I
Yes.
get it, because there are I have a lot of questions on a number of these.
Okay.
Can somebody explain how 2 and 3 are necessarily different? Or is one part and parcel of the other? I would think if you have capitalization to fund, operate, and maintain the facility, but you also need the financial resources to maintain the insurance, can those be combined? that as a requirement of the application, you have to provide proof of insurance, correct? Typically, that insurance will have an expiration, so you would know at some point that the certificate will expire.
Yes.
And didn't we talk about adding language that said that it has to be current and valid for a certain period of time?
Talked about,
This is back on page 9 under L.
on the next page, on the top of 10, we talked about having a 30-day notice of cancellation
Yeah.
endorsement. That's what we
Right.
talked about, so.
Okay.
Whereas the language was written at 7 days, so 30-day would be standard.
Yeah, right.
Mr. Chairman,
Yes.
I just wanted the commission to be aware that in bringing up the city's code of ordinances, the term moral character, that exact phraseology is used in 15 different sections in the current code of ordinances. For instance, the police chief shall determine moral character in granting certain licenses. So that language is used. It's a fairly common phrase, and perhaps, yes, some would say it is subjective, but it is a term that is used currently in, like I said, at least 15 different spots in the current ordinances, just so the commission is aware of that.
How would one measure moral character, though? And I'm not trying to get lost in the weeds on this either, but how would one measure that for anything, whether it's marijuana, or how would you measure that?
And I suppose I would follow that up with, I mean, some of the instances I know we've talked about before revolve around the evaluation of an individual, say for a, I believe, like a tattoo license or artist license, I think is one of them, right? But you're evaluating an individual at that point. In this case, I believe, and even in the administrative rules, it talks about all of the principals and owners of the operation. So how are we to collectively evaluate the moral character and integrity of all of those people? And then what does that mean for the purposes of evaluation if one of, say, 4 principals or owners is maybe of lesser repute than the other 3? How does that factor into the evaluation process? I think that understanding that it is used in other cases, maybe in this specific context, it's maybe challenging.
Do you have any idea what the state does as far as checking out a person before they give them a license?
No.
See, that's what we need to know. Because otherwise, we're duplicating a lot of stuff here.
It's in the rules. It's in the administrative rules.
And under the statute, M 333.27402, moral character is also referenced. It's under Section 3. In determining whether to grant a license to an applicant, the board may also consider all of the following. A, the integrity, comma, moral character, comma, and reputation, personal and business probity, financial ability, and experience, and responsibility or means to operate or maintain a marijuana facility of the applicant and of any other person that meets either of the following. And then it goes through a bunch of additional criteria. So that language actually is also used in the state statute. And it doesn't determine or doesn't say how one determines one's moral character. It just indicates the board may consider a person's moral character.
So, the state does their review, and the state's okay with giving this person a license. They bring the license to East Point, and the chief of police in East Point does his due diligence, does his background check, and he decides that he doesn't believe that they are of moral character. What legal position does that leave the city in?
Well, I don't think the police chief in this case is making that determination just with one person. I think it's the board that's considering that. I don't think it's just the police chief making that determination.
But they're under the same, they would be under the same guidelines. I mean, that they would have to determine moral character as well.
But I'm not, but in this case, we're talking about this particular ordinance, not any other ordinances. We're talking about this ordinance. And the board may consider someone or an applicant's moral character.
Okay, well, let me back it up a little bit. What if that board decides the moral character is less than adequate after the state has already said it is?
Well, the board would want to set forth its reasons, specific reasons for why. They couldn't simply say the applicant is not of sufficient moral character and we're going to deny it. They would have to state reasons for why they believe that. Because if they did not, it could possibly open themselves up to litigation.
Completely understand where you're coming from, but it's still way too subjective to me. Because you could be the most miserable person in the world, but hit all the boxes. I don't want a miserable business person in this city, but, you know, if this person checks off all the boxes, who are we to decide, or who is the board to decide, oh, well, he's not a nice man and he doesn't, you know, nobody likes him.
Well, moral character is not the,
Likability.
well, it's not the absolute determinative factor. You don't go through here and if you comply with all of them, but you don't necessarily make moral character, that doesn't disqualify you.
Okay.
There are certain other criteria, for instance, integrity, reputation, personal and business probity, which is exactly the language that's used in the state statute. But again, there are several other criteria that are looked at as well. And the board would want to go through each and every one of those criteria and determine, okay, we find that the applicant meets this criteria, and here are the reasons why.
Additionally, a lot of these factors that are listed on this form are yes or no questions. So if you had 2 applicants potentially that, or if you had 10 applicants that all checked off yes, there has to be some other factor that would differentiate. And then I think that comes back to the point of somebody has to make a decision of who's best for our city for whatever the criteria ends up being.
Yeah, that language that is in the proposed ordinance and in 1 is actually almost verbatim out of the state statute. But I believe the board has already decided to just delete that, but I just wanted to bring that to the commission's attention, that language is used in both the statute and other sections of city ordinance.
Well, then we're gonna need some language though that has some subjectivity. If 10 different companies all checked yes on all the boxes, how's the board gonna make a decision?
Yeah, I mean, I think taking a step back, so, well, actually, before that, first, I have a quick question. So the way this ordinance is written, the board would be the city manager or her designee, the economic development manager, or the building official, and the public safety director. Is that correct? Those are the 3 people?
Yes.
Have any of those 3 people communicated to you any critique, edit, suggestion, preference in these criteria at this point?
No.
Okay. But I think that factors for granting a permit, I absolutely agree with you. I think there are 2 questions. Like, what are the base criteria that people have to meet before they're even considered? And then once they're in consideration, how are they distinguished amongst each other for the purposes of rank ordering them for the permit, right? Because at some point, someone does, or a few people have to win, right, quote unquote. How is that determined? Which of these criteria are the ones that determine which businesses or operations get that license? I personally can't see that A1 is one of those. I would have a really hard time believing that public safety director, the city manager, and the economic development manager are going to, base the determination solely on character, reputation, or that would be one of the primary swing determinants. I would think that in their mind, that would be a base threshold. If one of the principles wasn't of moral character, then they would just toss the application. But getting back to what we said before, I think this all goes down a hole. I don't know if we want to put those people in, period. So,
I just don't like the
I think a lot of this is gonna be determined by whether they have a criminal background.
right, which the state does. That's part of the rules.
Well, wouldn't that also take into effect moral character? If somebody's got a criminal record, don't typically say that they've got a good moral character if they've got a, a
Well, it
criminal
depends.
record
Depends
potentially.
what their criminal record is for.
Absolutely.
Okay? Could be for peeping Tom, or,
That's-
That's where you go, really?
no, I'm just saying.
That's the first thing that comes to your mind? Real fast.
Well, there was something in the news about it, that's why it
Oh,
popped up.
okay.
Yeah, it was an attorney, too.
Was he? Just can't trust those people.
So, Mr. Albright, I assume that once when we make recommendations, will you be able to show the track changes to the council as part of the recommendation so they can see what we have and haven't sort of played around with a little bit, for lack of a better word?
What I would recommend the commission do is once the commission has completed its review, then I would get together with the planner and we would show a clean version without any changes, and then a version showing all of the deletions or cross-outs in red, showing what has been reviewed by the planning commission and the changes that the planning commission is recommending be incorporated as part of the final product. And then, of course, we would have a third version showing what those changes are, which would then go in front of the city council for consideration.
Based on the fact that this language almost verbatim is in the state statutes, based on the fact that other cities have the exact same language, based on the fact that we have legal consultation right here that is not saying we shouldn't have it, I would leave it in as a determining factor. Understanding it's a tough decision.
I can concede to the gray factor in it.
So now the suggestion is to leave it in.
Section 1.
We're discussing that right now.
Commissioners that haven't chimed in yet?
Yeah,
I thought we took it out.
Now the recommendation is to leave it in after the discussion on it. And as Mr. Broll stated, it is in the state statute, and the city attorney has given his reasons as to why it might want to remain.
No, let's leave it in.
We have 4 people that have said they want to leave it in. Mr. DeHaan?
You know, I was hoping when we came here tonight that we could shrink this a little bit.
Yeah.
You know, because that one, the ordinance that I've given you from Centerline, it's 8 pages. We got 23. Why are they getting away with 8 and we have to have all this stuff in ours?
Did they get sued?
I think it just, I think it's made ours cumbersome.
Have they been sued, though? Honest question, have they been sued? Does anybody know?
Don't believe Centerline's been sued, but I'm not certain on that.
That's the
Ah,
standard.
there we go.
I'm,
Note the word yet.
Aiello's indicated not yet.
Yeah.
I'm not saying that that's what we should have, because there's things in there that they don't have that's in ours, that I think it should be there. But I was kind of hoping we could reduce some of this.
I'll vote to keep it in.
I'm gonna stick with Walt here. I say take it out. There's a lot of words going on here. That, and like I said, I think a lot of these are vague and sort of duplicative, and if the state wants to make that determination, let them make the determination. I think we should make it as easy as possible for the 3 poor souls that actually have to make this choice. I say take it out, but
You know, when I was in the Army, we had a DI, and he said to us, if you learn nothing from me, learn this. He says, KISS.
yep.
Keep it simple, stupid. And I've lived by that, and it works.
Well, you're too much tonight. I don't know if I can take it. Good for Walt.
Take his coffee away.
Yeah. What's in that coffee, by the way? What is in there?
It's really good.
I bet it is.
Sorry, I'm not changing my mind. I've conceded,
Yeah,
so.
that's fine. Okay,
Still say leave it in.
moving on.
Mr. Broll,
Yes.
you were for leaving it in, right?
Yeah, I'm the one who brought it up.
Okay.
Thanks.
10
Wanted to
minutes-
make
10
sure
minutes
you
ago.
didn't change your
Have
mind.
some, have some of Walt's coffee. Maybe you'll change your mind.
So we're leaving it in?
Yes.
It's staying in,
You
yes.
lose.
Sorry, Walt.
Moving on. You and I lose, Walt,
Yeah, I know.
next time. Okay,
We owe you one.
yep.
Owe me a whole bunch.
All right, moving on to number 3.
I had thought Mr. Palazzolo had wanted to remove number 2. Is that
Or
still?
maybe combining them a little bit, because I think, ultimately, your ability to fund, operate, maintain, I think, is inclusive of maintaining the insurance. I don't necessarily know why we would need to break it out like that, but
Well, if you'll pardon my jumping ahead, that's part of the reason why I had a question on number 11. Because the business, or the applicant's business plan concerning the applicant's business experience within the last 10 years, history of performance and profit and loss statements for each business. So 2, 3, and 11 seem awfully similar in nature.
Yeah.
Essentially, it's kind of being a good business person. So that's why I had a concern there.
And it also, and the way 2 is written kind of duplicates what is written in the second half of 1 that we've now allowed to keep in.
I think
Which
11
also
is
ties back.
specifically pointing to a business plan document, whereas number 3 is talking about funding. So
Well, typically, if anybody's going for, unless they're self-funded, if you're going to a bank for money, they're gonna want a business plan.
I agree.
So that's why I think 2, 3, and 11 are very close in nature. And nobody's gonna lend money to someone who's had a history of losing.
I don't know if anybody's gonna, well, not a lot of traditional lenders, I think, are in this market.
No, but who knows what'll happen. Then the other question too, in looking, I mean, again, looking at 2, 3, and 11 together, considering the applicant's business experience within the past 10 years, so are we looking at all business experience? Are we looking at,
I'm sorry, where?
on 11?
Oh.
Are we looking at the whole thing? I mean, are we working with, are we looking at somebody who's been in the medical marijuana field and has a history there? Or are we looking at somebody who might have owned a Papa John's franchise?
And is this for every principal or owner?
Yeah.
This
so
could be a lot.
that's why 11, 2, and 3 are concerned, because, again, you get into gray areas. And my goal is to remove gray.
The interesting thing about this is a lot of these exact bullet points are written in the language that the state uses. I mean, verbatim.
But I think it's safe to say that the state has rolled this out incredibly poorly.
I'm just saying it's an interesting point that we're basically duplicating a lot of their work. And I'm not saying that's.
But to me, it does get back to the point, we have 3 people who will be evaluating this in the city. You know, all due respect to their experience and knowledge, some of these things may not be in their wheelhouse. Right? I don't know if any of them are CPAs. I don't know if anyone are financial analysts. I don't know any of that. So are they the people to evaluate a business plan and make a determination or a rank order determination as to who is most likely to be successful?
Dare I suggest we look at number 5?
Is it an automatic strike if you filed for bankruptcy or anyone filed for bankruptcy?
Mr. Chairman, that's one of the criteria that's in the state law.
Yeah.
That's verbatim.
Within 7 years, yeah.
So is that business or personal bankruptcy?
The applicant.
Doesn't differentiate, it just says it's actually the same exact language that's in the proposed ordinance.
Shouldn't there be some sort of differentiation, though? Because if somebody has filed personal bankruptcy, an LLC could be completely separate from personal or whatever, but shouldn't there be some sort of differentiation?
My point in bringing it up was how it rolls into a number 11 as well.
Absolutely.
Yeah.
If I go bankrupt because of healthcare bills because of my spouse, personal bankruptcy, but I'm still holding on to a business, does my personal bankruptcy potentially impact me getting a license, or vice versa? If my business has gone bankrupt, but I have the personal funding to do something, do you hold my business bankruptcy against me? And is that a mark against me? So, to me, that seems like there needs to be some sort of differentiation. There are way too many permutations to this, and that's why I've dragged my feet, as it were, because I keep looking at these and I keep seeing all this gray and unknown factors. And I know these gentlemen in the audience want to jump and get moving and making money and all that, but there's a lot of unknowns. Thank you, the state of Michigan, for putting together something with so much gray in it.
And it keeps being pointed out that this language is pretty much right out of state law, which was the first question I asked. If this is all out of state law, do we really need to duplicate it here?
Yeah. And why would we want to?
I agree. Why should we duplicate what the state has already done?
Yeah.
And Mr. Albright, would you like to repeat your answer to that?
Well, an answer to that is because the 3-person body that's going to be determining whether a license is going to be issued here in the city needs guiding factors. We're not talking about a lottery system. We're talking about using criteria to determine who is, meets the criteria that the city has set forth. And so this is the language that has set forth. I'm gonna go out on a limb here and guess that the other communities that have utilized this language probably took the position, well, if it's good for the state, it's good for us. And so that's why they have used this same language in their ordinances.
I defer back to my other comment, but are these the communities that are in litigation right now with whatever groups, you know?
I'm not aware of either Mount Clemens or Harrison Township, which is where this language came from, that either of those communities are in any type of litigation. I believe the city of Warren is in litigation, but I'm not aware of Mount Clemens or Harrison Township being involved in litigation.
So if we didn't make any adjustments to these factors, could we ask to have, so there's a 3-person body. And to Mr. Palazzolo's point, I think there needs to be some, if we're gonna leave these things in here about bankruptcy and adequate financial capitalization, then I think that there needs to be somebody from the finance department on that body. If we're going to ask these individuals, or say to these individuals, you're gonna be graded on your financial wherewithal, your business plan, your ability to get insurance, and all these other things, maybe we need somebody from the finance department in this group that has the knowledge base of numbers, taxes, insurance, business plans. I would think that Mr. Blum or one of his associates in the office would be more than capable of sitting on that body and lending credible knowledge.
If the commission is inclined to do that, to add members to the proposed board, just make sure, keep in mind that it should be a body that would not result in any type of tie vote.
We'll kick Mary off. She doesn't want to be on it anyway. She's told us.
Look, if we're being forced to keep this in here because these people need something to look at when a situation arises, why are we going through this and trying to make it smaller? Let's just look at it, and if there's any parts in here that are clumsy or really redundant, we can get through this in an hour.
And I would say this too, because I did mention this in a couple other meetings before. I would rather that the people who are ultimately going to be responsible for evaluating these things, they come up with these criteria, they review this language, and they come to us with a recommendation and kind of explain to us what they're thinking, because they're the ones that have to make these determinations. They need to start thinking about how they would evaluate this stuff now, because if we hand them something and then say, here you go, have fun, I don't think they're going to be very appreciative of that. So I would rather, let's table a discussion on all of these points, say city manager, public safety director, finance director. I think that's a great idea. You look at these, you tell us what you think you can work with, you revise the language, and you pass it back to us. We'll work on the rest of this stuff, and then we'll come to some kind of conclusion or consensus.
Mr. Chair, can I jump in just for a second?
Sure.
So this, we've had the proposed ordinance for 6 months in roughly the same language. Mr. Albright put it together back in July, and city administration's aware of it. If they had questions, they probably would have asked them by now, and once you're done with it anyway, they can address things then with the city council too.
No, I don't want their questions. I want their comments. I want to know what they think they can actually administer. If they have questions, they need to ask professionals, not us. We're a citizen board. What are we going to tell them? They are the professionals who are going to have to administer this ordinance. It is on them to make recommendations to us what they think is feasible. Yes, it has been out here for 6 months. Why haven't they looked at it by now? I understand we were waiting for a city manager. I understand we were waiting for an economic development manager. They need to get on this now. As the council member, I would have expected you to tell them, get on it. This is a pressing issue. We got to get this done. What are you thinking?
I guess I don't know, I mean, has this been an outstanding issue? I guess I don't, nobody,
Has it been an outstanding issue? Are you kidding me? How many times has this been on the agenda for the planning commission? How many times I've sat in the joint session the last time and I said, I want the people who will administer this to look at it and make recommendations to us. We'll look at the zoning and planning and site plan requirements. We'll do that. We've done that plenty of times. When it comes to the administration of the licensure requirements, the people who administer that, the professionals, should be the ones who provide the recommendations to us. Did you
Mr.
miss that part?
Palazzola, Mr. Palazzola, now that you say that, I am remembering at one of the joint meetings that this specific matter was discussed.
I know it was.
And there was a consensus among both groups that we would handle the parts you said we would handle, and that administration and city council would handle this stuff.
Yeah.
Now, we're trying to do our part. I don't know why they've dropped their part on us.
Yeah, that's my question.
give me one example. I guess I'm looking at, you're talking about bankruptcy here, whether the applicant's filed or has filed against it a proceeding for bankruptcy within the past 7 years. I think the three people will understand what that means and take that into consideration. I don't know.
Okay, let me ask a question
part of
on
it.
that.
Like, give me an example.
I'm reading number 5 and what it says. And this is coming right out of the state. So the state has put this language in, but what does it mean? Mr. DeHaan had an excellent point. Personal bankruptcy, business bankruptcy. If they've had a bankruptcy within the past 7 years, what happens? Does that mean they're disqualified?
If the state evaluates that and there's a personal or business bankruptcy, are they automatically denied pre-licensure? Because if that's the case,
That's what I'm asking.
right. No, exactly. That's I'm feeding off you. I get it. Right. Then they wouldn't make it past to pre-licensure, which means we shouldn't even evaluate them. Our standard should be: did you get to pre-licensure? Right. I mean,
To that point, what I would say is any of these items that duplicate, that are not subjective, like that one, should be removed. It's already done. We don't need to review that. It doesn't need to be in our requirements. Our requirements shouldn't duplicate exactly what's in the state code, which somebody has to pass to get to step 2, which is us.
right.
So, and I'll be honest, I haven't looked at all the information in the code, and I'm looking at it now going, there's all these redundancies.
Right.
So
What are we doing?
what are we doing?
Right. So if the state is going to evaluate, to Walt's point, moral resolute and whatever the language is, I don't care. Anyway, whatever that is, and they're going to make a determination, they're say, yes, they are morally reputable people. They should get pre-licensure. Then, okay.
the end of it.
So be it, right? I mean, that we're going to ask 3 people to second guess what the state review board has done?
We still need a differentiator if we have 10 people
I
in front of
agree.
us.
I absolutely
And
agree.
that, to your point, is probably better answered by, or perhaps is better answered by other people. I don't know, I'm kind of gathering it all now that I'm seeing that our code overlaps. Trying to process it and.
Yeah. Yeah.
Mr. Lubick, Chairman Lubick, could we call one of these gentlemen up and see what they went through as far as the state was concerned? I'd really like to know.
Good evening. My name is Chris Aiello. I'm an attorney located on Mound Road, and thank you for allowing me to speak. And I've been before this honorable board a number of times for a long time. Here's where you're missing everything. You guys are the zoning and sort of just how many locations for each category and where do you want to put it? And you're digging into the regulatory. So you're the zoning board, and then there's the regulatory ordinance. The regulatory ordinance is created by the council. And so that would mean sort of, and the council and the city attorney. What do I mean by that? Rich is on point with what he's done so far, but a lot of other cities have changed gears to some degree. A lot have. What do I mean by that? So they picked specific areas. Lennox tied in the scoring criteria in the ordinance to the tying into the sewers and the water because that's what they wanted. You guys, in your section with, that section is really old, that came out, that you're going over right now, the scoring criteria, needs to be changed. It should be a reflective nature of what you want in your city. So from what I hear from all of you is you want good operating people, right? You want people that are in the business, that have capital, that won't close the doors, and they'll be operating. And that's what I'm hearing from you. And so the whole scoring criteria needs to be changed. Mr. Pelzo's right on point. Like, if one stakeholder has a bankruptcy, what does that mean? And then you're all on point. You're good lawyers. And if the other one didn't have a bankruptcy, but one partner did, how does that score? Do you get 1 point? Do you get 2? So that section, Rich, I can help you with. We need to change that, and we need to figure out what the city needs. And from what I hear, you want good operators. You just want to have people that are in here that are in the business, that are going to succeed and not close their doors. Therefore, your scoring criteria has to mimic that. It doesn't. You don't care if they had all that stuff, because the state already did all that. And if they do, and if they had a bankruptcy but they still got approved by the state, who cares? It's a free market. They'll survive or not. They have a license from the state. They really did an incredible background. So the state of Michigan has what's called a Raymond report. And a Raymond report picks up not just convictions. They pick up your name if you were at a bar and you got into a bar fight and you forgot to disclose that. They pick up that type of information. If you were in a bar fight 20 years ago and you didn't disclose that you were in a bar fight and your name is in a police report, it gets picked up by this Raymond report. It's incredibly intrusive. I mean, like, intrusive. I had a client that was on a jet ski 25 years ago, forgot to disclose he got a ticket on a jet ski, and they almost didn't give him a license because of that. But that was under the old board. Things have really changed recently. But going back to what you're struggling with right now, you need to focus your criteria inside of your ordinance, or not even address it. Just put it in your scoring criteria. Just have, like, you don't even need to put all that stuff in there, because it is a tremendous amount of confusion. You just create a separate document calling your merit system. 100 points, 10 points for this, 5 points for that, 7 points for this, and 8 points for this, and 10 points for that. That's created by the lawyer and the council. The Planning Commission just put together where you want these and how many of them, and send it up to the council of a recommendation. Let the council and the attorney handle the application, the scoring criteria, how many points you get, how many points you don't get. Do you get all the points if you do well, or you don't get any points if you do well?
If you don't mind me interrupting, I'm sorry.
Sure.
If that were the case, then it should have come to us from council with the scoring already put in place. It has not come to us in that fashion. What has come to us has been this behemoth of a document that we are going through. Now, if it had been given an addendum saying this is what council wants, our discussion is done. But it was not given it to us that way, am I mistaken? Did I miss something? Because if it had been, I don't mean to be indignant on this, but this has been a long, arduous process, as all of you know. And I'm sure we've all made your head spin a few times, and I'm sure we've all been called a few things under everybody's breath. But the fact of the matter is, council did not send a list of criteria to us along with this ordinance. They did not say, nobody has said to us, council will handle this, you guys do everything else. We're hearing it, pardon me, we're hearing it from a biased attorney. Your job is to support your clients. Completely respect that. Our job is to safeguard the city of East Point. So if we are not supposed to be discussing this, and this is something that council needs to tackle, then I say we table this section completely, let council handle it, send it back to us, and then we can, whatever, make the final recommendation on it.
If you guys really want to know the truth, you've said it, everybody knows everybody's position. Send it up to council, give your recommendation on how many of these you want in your city and the zoning areas. That's about it. Let council handle the rest. It's up to them.
That's all in here already.
You're into the regulatory aspect, signs and merit and the application. You're dealing with the application now is what you're doing, but Planning Commission doesn't do that. That's up to the city attorney to draft with the city council the point system and how they are going to award the point. You already have like who's going to do it. It's a 3-person panel. You've got the meats and bones of everything you've done in the Planning Commission, and you know, the dog's been beaten enough down here that any lawsuit, you've already been in the planning commission and it's referred back now to the city council, and let them deal with it. Because they're gonna deal with it anyways. No matter how many more hours you spend on this, they're gonna take their time and decide what they wanna do anyways. It's no different than any other community. Just refer it all.
In other words, when you applied, they looked at you with a microscope.
Yes, sir?
So a lot of this stuff that's here, it's just redundant.
George Rohebe is not gonna go through
So-
SIDS and do all that. You don't need to do that. But Rich is right on point with what he did, but you don't need to worry about the person. You guys only need to worry about where it's gonna be and how many, and send it back saying, yes, this is where we want them, and this is how many we think you should do. You handle the regulatory with the city attorney. And then the city attorney can get lots of examples of what's come online, and I can help him with that. In the last months, with 3 cities that just came in line, all they do, he does the application with them. It's a point scoring system, and that's the tricky part. So you keep talking about lawsuits. Here's where the lawsuits did come in. Lawsuits have come in on an Open Meetings Act, which I can share with Rich and help him on that, how to avoid that. That's the first problem. The second problem has come on the scoring criteria, and that's easy to do because there's a lot of good fixes that have happened in cities in the last 2 months. Like theirs.
I appreciate your wanting to offer Rich assistance, but Mr. Albright is more than capable, I think, and he can handle this.
What I
But
meant is
appreciate
just
your offering.
is just by examples. That's all. I work with every city and every city attorney, and we don't know. I don't know everything, and sometimes I learn from the city attorneys things that I don't know either. It's a community between the lawyers. Sure, we do have clients, but we share information. We're a brotherhood. We know we can't do this and we can't do that, and it's not. I understand what you're saying, but it's not like that. Without me being able to consult with all the attorneys that I do, who are complete competitors of my clients, and I talk to these guys every day about how did you do this and how did you do that, and we have competitors, and the competitors know each other. Trust me, it's not like that. It's nothing like you're thinking. At this point in the game, we are all sharing information. We are all sharing friendships and information and knowledge because it's just too much to lift. It's just too big. So I think you just send it back to the city council and let them deal with the regulatory end of it. Thank you.
I'm worried this pain in my left arm is a heart attack.
I kind of like what he has to
Is
say.
it a stroke?
I think we're wasting our time up here.
So how about we send section 4A to city council and let them deal with it? Then we can move on, as we only have an hour, a little over an hour.
Mr. Chairman, or the planning commission could simply just state that this section on page 11 is indeed going into the regulatory realm, and the commission is leaving into that up to the discretion of the city council.
Is this meeting being recorded, YouTubed, whatever? Because I'm sure there are a lot of residents. I had some people reaching out to me, and
As far as I know, planning commission meetings are recorded. I don't know if this particular special meeting is being recorded.
There's people in there right now, so you can ask
If
them.
there are people in there, then they are recording.
can you confirm? I don't mean to.
Yes. Oh, it is on YouTube right now.
We're live right now. Yeah.
I was gonna say, I would think as long as the equipment is functioning, it is.
That's always the plan.
Amazing
Doesn't
how
always
many
happen,
people
but
refer to YouTube now, and blows me away.
yeah, there's 2 people watching you guys right now. Live.
Wow, we have an audience of 2.
Everyone else must have a life.
All right.
Okay, now it just went to 0, right?
You know what?
I wish we would have had this answer about 50 minutes ago.
Or maybe 6 months.
At least 50 minutes ago. What was that recommended motion, Mr. Albright?
Planning commission determines that this particular section is, in its opinion, regulatory, then you can indicate that this would be left up to the discretion of the city council and move on to further review of the proposed ordinance. And of course, the planning commission could take that position on additional sections as well.
I also think that we do need to have, if that language is gonna stay in there about financing, insurance and all that, I really do believe that we need somebody from the finance department on that board. So if it's kicking Mary off the island and putting somebody from finance on, or if it's expanding the board to 5 individuals, I really think it would behoove the city to have somebody with financial acumen on that board. And I really do like the idea of keeping Mary on as well, because building departments should be represented. Maybe it's just a situation where we find the 5th person, so there are no ties. And maybe that is an individual from the community, maybe, it could be anything, but, you know, that's another rabbit hole to go down. But I think there should be 5 people. There should be 5 sets of eyes looking at every application. Yeah, no, that's too cumbersome to you. That's all right.
That could be part of the recommendation, simply an asterisk at the bottom of page 11. Planning Commission believes that the board should consist of 5 members, 1 member of the Finance Department, and the 5th member to be from
Wherever.
X.
Actually, that's covered under this 4A 14E on page 12. Discusses the composition of the review board.
What is the number?
It's on page 12.
It's on page 12. Lowercase e, middle of the page.
There it is.
Yeah.
Yeah, there it is.
It's just paragraph E of 10-230.
I think we should add economic development, or, and not economic, I'm sorry. I think we need to add somebody from the finance department at least.
I have an asterisk at the bottom of page 12, and an asterisk by subsection E. It just says, Planning Commission believes the committee should consist of 5 members, with 1 of the additional members being from the Finance Department.
I can help you with these. Like, you're just doing medical marijuana. The state already required that you show a threshold of $300,000 in liquidity to get your license, only for medical. Recreational, there is none of that. So to add someone else on the mix that's going to add numbers, most people just attach their 401ks or their bank account statements. Or the state also took at times takes letters of loans. So you're going to send up somebody that can add, but I'm going to attach to someone's application that Joe Blow's, here's a letter of intent that they're loaning Joe Blow $500,000 to get into the business. So the state's already done it on the medical marijuana application by a CPA attested document. So a CPA had to attest to it. So I can walk you through all of this stuff to get you out of here quick if you'd like. You don't need to do that. So they've already determined that they're worth at least $300,000. Good luck. We did that, and that's in the statute. And it's in the application process. And a CPA, again, attests to it in a written document.
Sorry, still don't change my opinion on that one.
I know, I'm just trying to offer, I've been doing this for years, so whatever I can do to assist you guys. And I'm not just here on behalf of it's got to be a fair and open process, not just for me, but for everybody, right? That's the whole idea. Because I don't want to be somebody that's claiming that my client was fouled, so it's got to be open, transparent for everybody. And if I can help you get through this really quick, I'd be happy to stand here and help you with any suggestions.
In looking this over, I guess I don't have any problem with allowing council and administration to work through those portions of it until we get to page 13, the bottom of the page D, where it deals with signage. That is something that I think does fall under Planning Commission.
And lighting too, for that matter, especially with the.
Which any business is going to have to conform to our signage and lighting ordinances. It's just that these were some additional requirements that wouldn't pertain to other businesses.
Mr. Chairman, I know at a previous meeting, the Planning Commission did happen to jump ahead, and in my notes, that was one of the prohibitions. So under the second line, after flashing lights, the commission had recommended the language, any form of rope lighting.
And once we actually get to that on our regular agenda, that will not be allowed at any businesses. So it's not going to be just specific to, I shouldn't say not allowed, but regulated. We don't know what that's going to be, but we do know that we're not happy with what's going on now in the city.
I had that as change number 16. So I know that was done. It was done out of order. I believe one of the commissioners had looked ahead for that, and that was a change. So there was.
Yeah, I have some notes on here, but I don't know if those were notes that I wrote when I was reviewing it, or.
Yep, there was a discussion on that.
Okay.
I guess, I'm sorry, here's another thing that is a little confusing to me, right? So usually compliance with the sign ordinance would be part of the zoning sections, right? But a lot of these other operational characteristics are really related to the licensure requirements, right, in order to get the license. And that would be under a different section in the city's code, right? So, I mean, the city ordinances that regulate medical marijuana facilities are really going to reside in two places, generally speaking, correct? The business licensure requirements and then the zoning. So the sign, the reference to the sign requirements, I would think would be more appropriate in the zoning language than necessarily the business licensure, right?
Simply could say sign shall comply with the city sign ordinance, period.
Stuff's already there.
And that's what I'm saying. I think a lot of this, because I understand, this was taken from Harrison Township and Mount Clemens, correct?
Yes.
That it seems to, and I'm not sure which ordinance I'm looking at right now, whether it's Mount Clemens or Harrison Township, it sort of seems to weave between licensure requirements and zoning or site plan requirements fluidly, and to me, it's hard to read. It's very confusing. Like, we talk about special land use applications and site plan applications, like those to me would be in our zoning ordinance, not the licensure sections. So I would rather see those plucked out of here and shoved in our zoning ordinance. Like that would make more sense to me. And again, some of these, I'm pretty sure I've seen them in the Medical Marijuana Act or in the rules. So why would we put them here?
Mr. Palazzo, can you repeat that again, please?
Which part?
What you just talked about?
So, I mean, even as we get past the factors for granting a permit, right? So let's look on page 13, the operational requirements. Right? Medical marijuana facility must obtain a state license before they open a facility. I'm pretty sure that's verbatim out of state rules, right? No person shall reside or permit any person to reside in a medical, I don't know if that's in there, but no person under the age of 18 shall be allowed to enter. I'm pretty sure that's in there.
Actually, B, I think, is already covered in our ordinances on commercial properties.
Right.
Except where we now are allowing some upper story living facilities. However, we elsewhere have put language in for some separation with any, I believe the language was determined to be residential dwelling unit.
Right. It does seem to me, as has been indicated now a few times, that a lot of what's here is covered.
I don't think D was, with that language would, I find it hard to believe it would be in
The signs,
state law,
the signs.
especially driving 8 Mile.
Oh, yeah.
Yeah, regarding
I-
signs,
I'm-
it just,
I'm with you on that one, yeah. But that one, I mean, we're talking about operational requirements of a facility. I don't necessarily know if that is,
it's not really an operational requirement.
right, and it would be covered under our zoning.
So that should probably be moved to our section on zoning for it, Mr. Albright.
Commission could do that if it chose to do so.
I think that's where it is more appropriate.
There is also, before, since we're on D for a hot minute, there are 2 words that I desperately want added to this. There we go. Facilities may not use exterior signage or displays that contain an image of a marijuana leaf or other commonly recognized symbol for marijuana, or which utilize any of the following words: marijuana, whatever, weed, cannabis, blunt, doobie, joint, hooch, hash, or other slang terms. I understand that we've got the or other, but there are still 2 more words that I would like to add it in there in addition to the or other, and that would be dank and kush.
Never heard of that.
Drive 8 Mile or drive
Yes.
Rash.
How is it spelled? D-A-N-K?
D-A-N-K.
And what was the other one? Kush?
Kush.
There's a House of Dank and there's Motor City Kush, which has been closed for a while.
Is Kush spelled
I
C-U-S-H?
believe it's with a K.
Okay.
K-U-S-H. Big billboard pointing to a building with a locked lot, nothing going on there.
Kush.
I'm not usually one to like all other, but that kind of fits in this purpose, but. And then I had a question. Going back to signage, this would, I don't know, maybe I'm jumping ahead here, but, so we're looking at signs that say certain things about distribution is against the federal law, blah, 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 all this other stuff. I would like to see some sort of signage in parking lots saying it is unlawful to smoke in a parking lot. Is that not, is that,
Dispensary.
yeah, in a dispensary.
I didn't, you know, I don't know if that's even in here.
If they want to smoke in their cars or driving somewhere, that's fine, but it does not need to be in a parking lot smoking.
I don't think they're allowed to smoke in cars when they're driving.
Then,
I've seen people doing it, but it's
I
not
have
legal.
too.
Yeah, I know.
But we don't need a little Cheech and Chong, you know, I don't need to see the mystery machine in front of somebody's building with a big old puff of smoke coming out. So, yeah, I know, I was, you know, mixing my metaphor there.
I don't know, Scooby Snaggy and those Scooby Snacks.
Could have been the original pot brownie, but the point being, you know,
Let's just say
we
they
don't
were
need that
friends.
type of thing going on in a parking lot. I mean, I drive down 8 Mile, or drive down Gratiot going to work, and I see the people coming out of the old Church's Fried Chicken, line of people trying to get in. God bless them. I bet they have a heck of a business. But how many of those guys are sitting in the parking lot blazing one? That might be another word I want added, is blazing. So I just think it's very important to have signage, and not just one stinking little sign somewhere, a couple of them posted in the parking lot, that it is unlawful.
Put them up. It's illegal, he's right, but I've been in stores for 3 years and I've never seen it happen once. Listen, they're in for 5 minutes and they're in their car and they're gone. It's a pharmacy. But
That's a
I don't wanna
stretch,
see any
but I'll
Cheech and Chong
defer.
either. I'm with you.
I think we put it right on the building at the door. So when you're walking in, that's the first thing you see. So when you leave, you know, get in your car and drive away.
I don't want to see just one sign. I want to see a few. I want to see 3 or 4. When you go in, when you leave. One in the back, if somebody's going to park in the back.
Well, if you look at section 10-232 on 17.
Well, let me relay a story from a couple weeks ago when a dispensary on 8 Mile opened. There were a lot of people that did not read the signs in the adjacent businesses that said parking was prohibited and you would be towed. I have a feeling the towing companies made as much money as the dispensary did.
Was that the cookie one?
Yes. I also admire the food trucks that showed up and parked outside of there.
Just one sign. On page 17, under,
Wow, I only got up to 16.
Sheila made me jump.
And again, this is probably still something that we may not even want to be looking at. But I saw item V on page 16. And I only questioned it being in there because we are not allowing grow operations.
There is none of that in a store.
And I can't see any of that in terms of a dispensary, a secure transport, or a testing lab.
Can we strike it?
That's a question for Mr. Albright. Again, that just seemed like language that was in there that didn't really need to be in there because
I'm sorry, can I just confirm which section you're talking about?
Page 16.
page 16,
V.
V.
Thank you.
Mr. Chairman, was there a consensus on the sign issue? I know we jumped ahead a little bit, but I know
Which sign issue?
Mr.
We
DeHunt wanted to add certain words, but then there was some discussion about just moving that to the general sign ordinance and taking it out of here altogether.
I'm thinking that should be in the sign ordinance.
Okay.
We do have a section in there that I know for sure that is specific to gas stations.
Okay.
So marijuana facilities would not be something unusual.
Okay, so we're on page 13, under proposed section 10-231, we're gonna remove subsection D altogether and shift that and put that somewhere in the city sign ordinance.
Yeah.
Yes.
Plus,
It'll find its home alongside the words, I believe, that were cush and dank.
Dank and Kush, yes.
and no rope lighting.
It's not a sign wall.
Thank you.
All right.
While this gentleman is up at the podium, I asked Eric to come here because I wanted to ask his opinion, but seeing you're here, I would like to add into our ordinance in the security section that if a side or the back or the front of the building is open to where somebody can drive into it, okay? I would like to see those metal cement posts around those areas so that nobody can drive into the building. Do you think that's a good idea?
Well, to make you feel comfortable about the security requirements required by state law, every inch of the facility has a camera on it. And they want you to be able to see down the street with your cameras too. So if I took you into the facility and showed you the 2 screens that are up in 2 stores that I've been in a lot lately, there's 37 little screens, and then so not only that, but those screens must be able to print. If the state comes in and says print that screen, you have to print it in color. And then if the state says print that screen in color 27 days ago, you must be able to do it within a 30-day window. So to address that, so that's what happens by state law. But you're talking about the blockades. I do not see that as a necessity at all. Around the whole building, no, I don't think it's necessary.
Before we get to your bollards, or whatever it's called, I have a question since you
Sure.
opened the window on this.
Sure.
Is there anybody that monitors these screens, or is it just there, and
Yes.
if something happens, you go back and you consult the video?
Well, the manager, we put them in the manager's offices, so when the manager's sitting down, he sees it all the time. And then some places have security guards. Most places have security guards that, have SOPs. So they walk around the outside every 10 minutes and in the parking lot every 10 minutes and in the interior. But I'll be honest with you, in some stores that I help manage, I don't think security guards are necessary in some areas.
So you have stores yourself?
That I oversee, manage, help, yeah. Well, on the regulatory aspect as the attorney.
All right, so then, before I get too far down this hole, so if there's nobody watching the screens, and let's say it gets busy, and I think didn't they say there was like 2 to 3 people typically run a store at any
Sure.
one time? So if it gets busy, how do you know somebody's not stealing you blind?
Same way
If
any
nobody's
business
watching
does.
if nobody's watching the cameras,
So I can answer that. The product is regulated. It's behind the counters. So
every product in that store will be behind a counter, whether it's a wrapper or everything is behind a counter.
every product by law is behind the counter, not accessible to the public. Every product. Every piece of candy, every chocolate, everything is behind the counter.
Okay.
Yep. You need to come and check a place out.
That's okay.
You do. It'll answer all these questions. You're going to walk in and go, oh, we spent 6 months on this, and this is what the store is all about. I'm telling you. Just come on, I'll pull a bus around, and we'll all get in, and we'll spend an hour, and we'll go to 2 stores, and you're going to come back here and say, send everything to the council. I've seen
He's
it
sending
all.
the short bus for
The
us.
magic bus.
The reason I brought this up is,
No, there
and I had Eric come here, because he just bought that facility that the lady from Channel 2 owned, Q.
Sure.
Okay, now if you go back a year ago, there's no setback on the back of their building. It's right on the sidewalk. And some guy in a truck pulled across the street and backed his truck right through the wall, okay, and gained access. Now, I have a store by me, it's called Liquorland. He's got posts all along his parking lot and all across the front. And I said to him, why'd you do that? And he says, you know, if somebody drives through my building, the insurance company will take care of the wall. The insurance company will take care of all the stuff that's damaged. But he says, I lose a lot of money because my store won't be open. Correct?
Correct.
So to keep that from happening, I think it would be worthwhile to do that. The other thing that, and I just want one more thing. The other thing I want to look at, putting in here, is no windows under 5 feet off the ground, and they should be either in bulletproof glass or in glass block. Yes, no, or indifferent?
If you don't mind for a second, Walt,
I
do you mind if I?
of course, yes.
I respect where this is coming from. We're not a police state.
It's not,
We're not a police state, and it doesn't need to look like a fortress.
it's not a fortress.
Well,
You can have.
I mean, putting bollards
you can
around
have
it.
a nice
and-
facade on your building, instead of having the window this high off the ground, it's this high off the ground.
Well,
And you can have it look nice.
But-
But they can't get in.
I get what you're saying, but I don't want these to look like little fortresses, and I don't think we need to be surrounding them with bollards. And quite honestly, if somebody breaks into their business,
What's your opinion?
that's on the business owner.
All of them are not necessary, because then how do you protect the roof? They generally like to come into the roof anymore.
It would
because
be
it's
on,
easier.
it would be on the business owner. If somebody goes through their front window, and that's on the business. It should not be on
That
us.
business keeps getting broken into, who's gotta go there?
Then the business owner will make the adjustments, and they'll come before us or come
police
before wherever.
They're gonna be very, very busy.
And that's why they're paying $5,000 a year in fees and all this other stuff. I don't want to,
I just want it stopped before it even starts.
It hasn't started, so it doesn't need to stop. Walt, you need to come to a store. I'll pick you up at home and drive you there and bring you to a facility where we can educate and talk and walk through it. You're gonna come back here and say, send everything to the council. We're done. You're just gonna be amazed.
So you wanna leave it up to the business owner?
Yes, yeah, of course. Yeah.
the onus should be on them. They're the one investing $1 million or whatever it is.
'Cause-
And if they're getting broken into every other week, well, you know what? Sorry. And then maybe when it comes time for the application to be reviewed, and this establishment has been broken into 5 different times, maybe they don't get the renewal.
My concern with going down that road is every business has a potential to be broken into in that manner. So why not require that on every business property? And then it becomes an aesthetic issue. If it's a business decision by the business owner, that's one thing. But, pharmacies have opiates in it. We need to put those around pharmacies so they don't get broken into. And banks have money in them, so we need to put them around, and shoes are a hot commodity, so let's put them around Foot Locker. And, they like to steal cigarettes, so let's put them around tobacco stores. I mean, let that be an individual business decision in my mind.
That's I will say, Walt, you almost had me with the bollards. The bunker window thing, I wasn't gonna bother, but, I mean, I was almost with you, because I've seen plenty of stores where 2 guys stole 2 different cars, drove both of them into the building, or drove one of them into the building, packed up stuff with the other one, and then drove away. It didn't matter what you got on camera, because both cars were stolen.
And
both
doesn't
were
the
damaged.
product have to be secured in a vault
So,
in dispensaries?
yes, so the vaults that we've built are, one's 9 by 20, and it has all the camera systems in there. It's got its own cooling system, and all the product goes in there at night, and it's a safe vault door. Like on TV, you see those doors? Most everybody has that, and in the grow facilities everywhere. You need to come check them out. You're gonna get you're gonna feel much more comfortable that these are coming into your community. You're going to. You just gotta come.
It's not so much about the comfort factor, it's about, this is a broad community. I get we have a lot of young people think it's hip and great, but there's a lot of mature people that live here. I mean, you might not see them out there that often, but they certainly vote via, absentee ballot. They're here. So there's more to respect in this community than just the young.
So I
and
can
just the
share with you.
cannabis friendly.
In the first 3 months that a project opened in Ferndale in 2019, 42% of their customers were over the age of 58.
It was ironic. I was at the gym the other day. It's amazing what I learn at the gym. And I was on a treadmill next to a lady who actually spoke in front of city council and was at one of our first meetings all for marijuana. And she actually said something to me because she had just gone to the dispensary across 8 Mile. She said, I don't think we need them. Dispensaries. And I'm thinking, oh my Lord, you spoke for this, wanting this because you wanted to be able to get your medicine. And I was taken aback. I think I almost fell off the treadmill. So, you know, there's a lot of shifting and bobbing and weaving in this whole thing. So, you know, y'all need to keep an open mind that there's still a lot of people that don't want this in the community. Y'all might want it because you're going to make money and everyone's going to be happy, but there's still a lot of people that don't like it. So, hence us being almost to the point of being litigious and being very anal retentive about everything in here. So, again, no offense to anybody, but we have a lot more than just a small portion of the community to think about. I defer my soapbox.
Refresh me, what time are we,
9:30.
hard stop?
8:30.
Wasn't it 8:30?
8:30.
I thought it was 8:30.
Where are we at, 16? Page 16?
I think all of this stuff, these are things we can defer to council. I mean, if they want to take V out, then so be it, you know, whatever.
So V stays in?
Yeah, I would say just let it stay in and let council figure out what they want to do with it.
You could put a note on there that it probably isn't necessary because we're not allowing
Yeah.
grow facilities.
Yeah.
Oh,
So are you on 17 now?
yeah, I'm looking at some of my notes that were written months ago. And this is under operating
Yep.
standards, so again, it's not something we're going to have a lot of input in.
I think we do have something to say about A, especially if it's a special land use. We've regulated hours of operation before.
Okay.
I think especially if we are allowing facilities within 100 feet of residential properties, I think 9 PM is too late. Ten 232A.
Top of page 17.
So, I'm sorry, can you repeat that?
I think that the 9 PM to 9 AM, I think the start of that is too late in the day.
What time do you,
I would go at least to 8, if not earlier.
why, contrast that with liquor, though? Like, liquor stores are open till,
Yeah, and I don't think,
I know you
yeah.
voiced that
Yeah.
before, I know that.
Right. If we're gonna allow them within 100 feet of a house, I don't want them. I don't want them open till 9 o'clock.
So you're recommending 8 PM to 9 AM?
I might even go take it to 10 AM.
I'm assuming you have stores.
Yeah, there are stores that I help regulate. The cities are usually 10 a.m., 8 to 9 p.m. 9, some communities, you know. Summer, it's still bright out. Winter, we just have to deal with 4 o'clock, you know, getting dark. But if the you know, pharmacy's open till 9 and the liquor stores are open till 9, why hurt this industry? They regulate themselves. They figure out their own traffic goes on Sundays. They just know their traffic patterns.
I can agree with Mr. Palazzolo.
I'll support Mr. Palazzolo, sure.
So what are we supporting?
8 PM to 10 AM?
Any other comments on that? Any objections to recommending that change?
8 PM to 10 AM?
Mm-hmm.
Just looking at the rest of it, from B to T, it almost looks like that's probably straight from
Yeah.
state ordinance.
Mr. Albert, wasn't there something, were we talking about that the recording should be longer than just 30 days? Wasn't that?
I had 90 days, but I didn't have that as something that was agreed upon.
That was a note that Laura asked that I bring up to you today
Yeah,
for
that
your
needs to change to
consideration to
90
change a period of 30 days to a minimum of 90 days.
I had 90 days as well, but I didn't have it marked as one of the changes that had been agreed upon, but it was discussed.
Yes, I have that marked in here, and I also have Laura's initials next to it, which was indicating it was a recommendation from her. And I have a question on H near the bottom of page 17. Provisioning center shall not allow the sale, consumption, or use of alcohol or tobacco products on the premises. Do we want to add vape to that? Or is there marijuana products that are in vape form?
Yes, but we're not allowed, the stores are not allowed to have any of that on their premises. You lose your license. You can't sell, you can't consume any type of product on the premises. So smoke, vape, eat, inject, however it's done. You can't do any of it on the premise.
Okay, but this is specifically has the word shall not allow the sale.
Well, that should be out. Well, oh no, that's a use of alcohol or tobacco, so that's fine.
It shall not allow the sale, consumption, or use.
Of alcohol or tobacco.
And that's why I'm asking
That's
whether or not, what effect putting the words vape products in there would be.
Oh, you would not be able to preempt state law. State law is a definition of marijuana as a vape product. You couldn't do that.
Okay. Because I know that wasn't an issue back when we first were handed
Right,
this, and over the last 4 to 6 months, it's suddenly become a very big issue.
Yeah.
Mr. Luvick, are we, that area, C, instead of 30 days, it's going to be 90?
That is correct.
Is that 90 days or 90 days minimum? Or does it matter?
For a minimum period of 90 days.
Okay.
I believe that's what the recommendation was. I mean, if the facility wants to hold on to it forever, then.
Well, I think Rich will have to do a little research on what the state law says versus what an ordinance can do. You're generally not allowed to preempt state law. So general rule is, when I discuss with cities is just the catch-all phrase is you must videotape everything you must video and record everything that the state law requires you to do. So you understand, so like you say 90 and it's 30 on the state law, that's an issue if someone says, hey, I'm not doing 90.
I think the problem there is state law says 30, we can't come in and say 15.
That's what I'm trying, well, no, you can't come in and, you can't make them do more. You can't make them do more. You can do under. You can ask to do it under, but he still will have to do it for 30 for the state. You can't
Well, that's
make
what
him
I'm
do more.
saying. We can't say 15 days, that preempts state law.
No, you
If we
can't.
say 90 days, that's still within
No, you can't.
the 30 days that the
No,
state law
you're not
requires.
preempting it at 15 because it's under 30. If you said more than 30, now you're preempting it because you're making them do more.
I'm not understanding what you're saying. How can we tell a facility that you have to save it for 15 days to comply with us, but the state says you have to have it for 30?
So you can do that because you're not preempting 30 days. You're not preempting. You're coming underneath it. So you can do that.
Well, we'll have to ask Ms. Hall.
You could just indicate that video recording shall be maintained in a secure off-site location for a period in accordance with state law.
You could try that, but Rich, you might want to look at it. We have to keep them on premise for instant checks. So they'll come in for inspections, and they come in and where's your video recorder? Where's everything? Show us. And they're not going to go. I don't think there's a second.
Unless Mr. Madigan has any more insight as to why Laura had made that recommendation.
Unfortunately, I do not. I wasn't here for your January meeting, so I'm not aware of the discussion around it.
So
Okay.
if the
think
if the
that's
video is
overkill.
obligated to be on site for a certain amount of time, then maybe a video after a certain amount of time is held off site for a minimum of whatever. So if the state is mandating that they have video records on hand for 30 days, then you keep that in your store, and then the prior 60 days, keep that off site somewhere, whether it's in a safety deposit box or at the owner's home or whatever, just so long it can be made accessible.
Mr. Albright, question.
I think it's overkill.
Section 10, 232, 233, and 234, is there an easy way to determine if these are just simply state requirements, and we're just regurgitating the state requirement right here in our ordinance? Is there, to me, I have a feeling a lot of this is gonna be covered, and
think a lot of it's in there.
we're just talking about things that are already required.
Yeah.
Going back to Walt's earlier discussion about keeping it simple, this would be really easy to trim out if that's the case.
Right.
And make our ordinance.
Right.
I need a little clarity, though, on page 18, section 10-232, letter L. All marijuana delivered to a patient shall be packaged and labeled as provided by state laws. Are we delivering to customers?
Yes.
So we got Duber, is that it? We got doobies on the road that will go to, and if any one of you patents it, I'm getting a piece.
That's funny. That's funny.
But seriously, so you're telling me that the marijuana facility can, and if there's a big old joint on top of the car as it pulls up, this is going down a bad road here.
delivery is starting in.
Yeah.
Delivery is,
They would probably know better, but I believe that the first delivery business just started operating in the northern part of Michigan.
They're operating everywhere, in Ferndale, everywhere.
For a while?
Chesney,
Okay.
Ferndale. Home deliveries is allowed under medical marijuana law. Yes.
so,
But there's strict rules. You can only deliver to 10 people. You have a strict GPS. You have what do you call that? When you go on the road, the truck driver has his
CDL,
Electronic vehicle logs.
you have
EOL.
whatever. It's you got to keep track of everyone you go to, and it tells you who you can drop it off to and who you can't. And 10 times, then you got to go back to the store. It also says you're allowed one bathroom break, and that's it. It's like intrusive.
so why isn't that information then?
You don't need it because it's in state law. You don't even have to address it.
Well, most all of this is state law that we're just regurgitating.
A lot of it
as
is.
we've said, so why
I think
shouldn't?
Mr. Albright's looking that up right now.
Because if it's in state law, then maybe that needs to be incorporated if we're going to start having people rolling around dropping off medication, which I have a hard time calling it medication.
Excuse me. What is your name, Mike?
I'm sorry, my name is Chris Aiello.
Chris?
Yes.
Do you think that 90 days is an overreach?
You can't do it. You can't go to the store and tell them 90 days when the state said only 30. You can't preempt state law. Just put in there whatever the state of Michigan says you have to do, follow it.
I mean, if there isn't anything on that in 30 days, why are we keeping it?
I'll fall back on what the law says, and you can't preempt state law when it's in a specific area, and that's what this is. You can't force a store to do that. Don't put yourself in that position. It's 30 days.
I'd like to find out why Laura asked for that, though. Because she doesn't just ask for things just to do it.
It changes every month, too. There's new bulletins. If you go onto the sites, the Marijuana Regulatory Agency site, every week there's a bulletin. It's changing the laws every week.
You know, I got up in front of council one time, and I told them, don't be in a big hurry to get this out on the street. Because I spoke with Kevin Hertel, and I asked him about the law. And he says it was the worst rollout of anything the state has done in a long time. And they're still fixing it. And the same thing is happening to the one for recreation. Those guys just can't get it together. So you're going to have constant changes until the dust settles. And who the hell knows when that is?
It's Like musical chairs, who's gonna be without a chair, though? Duber. I'm gonna call the patent office tomorrow.
Mr. Broll, in answer to your question, I've looked ahead. If you look at page 21, section 10-234, minimum operational standards of a secure transporter, for instance, that is covered by MCL 333.27503, which discusses and provides for secure transporter license. The language in the state statute appears to be nearly identical to what's in the proposed ordinance.
Thank you, appreciate it. Yeah, we're wasting our time here with this.
Yeah.
Let's just move on to 10-235.
Let me ask one question before we get off of this transporting and delivery. Deliveries are not made by a secure transporter.
No, home delivery is done by your medical marijuana license and your home delivery plan. So you have to, the state of Michigan has a requirement that you submit a home delivery plan to them. So you submit a plan to them, they approve it, and they send it back to you. And what I said earlier are the basic outline of how it operates, how the plan operates.
Shouldn't those things be provided to the city as well?
No, because the state regulates it. So you guys have nothing to do with this after this. All you gotta do is say the number and send it to council. After this, you guys are done. All done. The city's all done. The state regulates it. The city has nothing to do. The police aren't gonna come in there and do anything except be good partners and come in and say hi. That's it. The city's done. You will have no expense. There will be no expense to the city. Nothing. Nothing. It's all done by the state.
But we've never done anything for the residents in the city because of expense. You know, I've heard a bunch of people tell me we're gonna make so much money because you have medical marijuana facilities. We're not going to make money. It's never been about the city making money. It's been about being good business partners and being good stewards of the city. And I'm sorry, but I get so sick and tired of hearing people say, oh, we're gonna make all this money. No, you're gonna get some property taxes. That's about it. You guys are gonna make the money. We're not gonna make the money. That's fine. That's why you guys are investing millions of dollars in buildings, security, product, and all that. So please don't feed us a line. And if you hear somebody saying that the city of East Point is gonna make a lot of money over this, please correct them. We're not in it to make money, and we're not gonna make a lot of money. We're doing this because some people wanted it, and that's that. Sorry.
Rule 35, Section 10. Licensee shall keep surveillance recordings for a minimum of 30 days.
Yes.
Under state rule.
Well, you know what, Mr. Albright said, related to the state. You know.
Well, the state seems to leave it open. It says
Yeah,
for a minimum of
30.
30.
Minimum of
It can be longer. So, I don't know. I await Mr. Albright's treatise on preemption, so. Well,
I guess he'll get with Ms. Ha on that and figure out how 90 got into our notes.
I'd be happy to do so.
She asked for it for a reason.
Okay, on the top of page 19, there is some language about signage.
it's at the bottom of page 18 too, it looks like.
Yeah, it starts on the bottom of page 18.
On Q, should we add the plus symbol? Didn't we
Louis,
discuss
where-
that once
where you
before?
looking?
You mean the green cross?
Yeah.
Would be where we would probably put that. Or roll that into the other section that we discussed earlier that we're moving.
What do you want to do with R? That doesn't belong, that belongs in the zoning.
Mr. Albright, do you believe on page 18 at the bottom, O is even necessary?
No.
Can we take out O? Is everybody okay with that?
Yeah, that's, your signs must comply with local or state laws. That's kind of obvious. Now, Q is just kind of redundant of
Right.
what we had earlier. From page 13, section D, that's,
We would still need to add the cross in there, though.
did you get that, Mr. Albright?
I have,
Desire to add a green cross into section D that we moved earlier from, is that page 13?
we're adding that to the words dank and Kush.
You'd be at, above that.
Commonly recognized symbol,
Yeah.
image, this place contains the image of a leaf or other commonly recognized symbol. Mr. DeHaan has specifically requested the green cross. Did you want to put the zigzag man in there too?
Now, if they want to pay the fees for copyright laws and all that, God bless them.
Is subsection Q on page 19, is that being deleted?
Yeah, because that's pretty much covered in that other section D from page 13.
What about subsection O on the previous page, or P rather, on the previous page? I know O is being removed, but what about P?
I guess we can put that in with D as well.
Can I make a comment on that, Mr. Chairman?
Yes, please.
And sorry, it's something I brought to Rich earlier. So, I think we should be careful about prohibiting certain things from signs, and the basis by which we are prohibiting them is the content of that sign. And so, specifically in section P, to prohibit advertising material which is misleading, deceptive, or false would be prohibiting a sign based on its content, which is not something that municipalities are permitted to do.
Good point, because there's signs all over that says Red Bull gives you wings. I know some serious Red Bull drinkers, and I have yet to see their wings.
So P's being removed?
I'm fine with that. I'm fine with P going.
I guess I might want to reword it in that I like the idea that it isn't designed to appeal to minors.
So, and I believe that your section and a lot of sign sections have provisions which allow the administrator who's reviewing the application to prohibit signs that are lewd or something of that nature. And I defer to Rich, but I would lump advertising marijuana products to minors in that category. I think that there is more discretion for the person administering that ordinance to prohibit based on that factor. But the misleading or false advertising, I don't, is not a place for a city staff member or board to judge.
That's cool.
Well, if somebody's using false advertising, it would go towards morality. And automatically, it seems to me that if you're trying to keep morality involved in this ordinance, if you're using false advertising, that's kind of a disqualifier for potential license renewal or a potential license.
Well, I think the point we're getting at is that these are really the purview of an agency that is outside of the city, and we should leave it there.
Anybody want to discuss on page 19R?
Isn't that in the very first section? And if it isn't, just move it there. That's zoning.
First thing I think of when I see this is a billboard.
That's the first thing that came to my mind.
Lord knows we've seen enough billboards.
I don't know, this language is broad, this is really
there's nothing
broad.
here on that.
In any form or through any medium. I don't know. I don't know about that one.
I mean, I agree with it, though. I don't think I want to see a big old billboard near a church or a school.
Well, then, if that's the case, then I think we should, well, first of all, I mean, we have billboard regulations already, but, I think we can address billboards. I think that the broad context that R casts is, a little scary, to be honest with you. So if a pamphlet shows up, just happened to be dropped off somewhere, and it's within 500 feet of a school, yeah, I would find that objectionable, but, I mean, regulating that, I think would be virtually impossible. How are you gonna prove that the facility or the product or whatever it is that is conveyed through the advertisement is the one actually responsible for placing or causing it to be placed within 500 feet?
Agreed. Somebody could drop it on the ground, the wind could blow it down.
Who knew? Yeah, I mean, if we want to talk about billboards, I mean, that's a separate conversation, but this language is far too broad, I think.
Mr. Albright might know the answer to this question. I believe we only have one billboard left in the city,
It's right up here on Gratiot,
Gratiot and 10 Mile.
yes. Facing, traffic heading in a
South direction, yeah.
direction, yes. It's on the west
South
side.
and west direction.
It's on the west side of, Gratiot, southbound Gratiot.
Ironically, right above the plum pit.
Isn't there one at 8 in Gratiot?
There used to be at one time, but
think so.
that's been gone for quite a while now, I believe.
Because I heard that the mayor was using it.
Well, Mr. Jakubiec, it's just south of 8 Mile, like the one
I think
you're.
it's on the Detroit side.
That's on the
Talking.
Detroit side, all right.
I don't think it's within the city's boundaries.
And I guess if we did say something about this, we could not enforce it outside of our city limits.
That's correct.
Are there any billboards along 94 that are on our side of 94? It's all on the
Not aware of
east
any. I
side.
know there's one, I believe, on the St. Clair Shores side of 94.
Yes, just north of 9 Mile.
Is there one at 10?
I don't remember.
Yeah, by the collision, or I think it's by Genesis.
Yeah, collision and the self-storage facility there, in that general area.
Is there,
It's not a billboard, it's an extremely tall gas station sign that for a brief moment said Subway underneath it. If anybody remembers that one. I think that Subway had a grand opening followed by a grand closing.
Is it 9:30 yet?
Yeah, I say we recommend removing R.
Or do you want to reword R to pertain to billboards?
What do you want to do?
Although knowing where the only billboard is in the city.
Yeah.
Could we add a simple word in there maybe and say no licensed provisioning center shall purposefully place or maintain? Could we do something like that?
I think that's kind of like cause to be placed or maintained. It's,
There we go.
well, that's what cause, yeah. So I think that's synonymous in some ways. Although purposefully involves intent. Cause is a little more.
I kind of like the word purposely because if they're purposefully doing something like that, then it's like kind of like if I give you a bunch of brochures and I say, hey, if you want to give these out, you can, as opposed to paying you $10 to pass out a brochure.
So what are we defending against with this statement? What is the concern?
Billboards.
Just billboards, is that?
Well, yeah, I think it's anything. I could see, the city, I mean, I get the intent. The intent is to prevent the city from being littered with pamphlets of medical marijuana product. That's the intent. Especially in areas around schools.
Are these permanent advertisements, by the way? Are these permanent
I think the way,
pieces?
I think,
What I can see is, for instance, the cruise day is sponsored by, or one of these companies, a provisioning center is going to advertise up and down Gratiot. To your point about
Yeah.
it'll be splashed everywhere, I can see that for sure. And but those would be temporary, right? So
yeah.
But likewise, they could hire a company that has truck-mounted billboards to drive up and down Gratiot, not in the cruise lane on that day.
that's why I was asking if R is a permanent or a temporary type thing.
I think it's meant to capture. The language is very broad. Any form through any medium.
Mr. Chairman, if I might, the comments that I made previously about the sign and the false advertising apply in this scenario as well, from my perspective. If the sign meets the dimensional and locational requirements from our sign ordinance, the content that goes on it really can't be dictated. I can't comment on the passing out of pamphlets or things of that nature, but at least for permitted signs from a locational and dimensional perspective, prohibiting advertising marijuana on it, I think would be difficult.
Do you think that the same standard would apply? To me, a pamphlet is something completely different. It's a marketing piece.
I can't comment on the pamphlets at all, just from signs that the city permanent signs or temporary signs that the city permits. I would ask Rich about the pamphlets.
Mr. Albert, what is the ordinance on billboards? Do we have one?
The ordinance on billboards, that would be covered under the sign ordinance. That would be covered under the sign ordinance itself.
We have one that would regulate where they can be located, how they can be illuminated, and what size they can be. but there's nothing in the regulation as to what can be advertised on them. Which is what Mr. Madigan is saying. If you're allowing the billboard there, you really can't regulate the content that's going to be on it. And the one billboard we do have in the city, I don't believe is within 500 feet of a school or a church. I could see where the one, and I believe it's on the other side of 8 Mile Road, that billboard might be within 500 feet of a church that is also in Detroit. But how would East Point regulate who puts what on a sign in Detroit? You really can't. And I'm wondering what other advertisement forms we would have in the city that we might be able to regulate. You can't put signs between the curb and the sidewalk, so those are already prohibited. Oh, they happen far more than they should.
Do we regulate billboards that get put up? Like, say, right now, we only have the one, but what if somebody wanted to put up a billboard at another location?
If it met our zoning requirements, they could.
I wonder if T could resolve this. All provisioning centers shall comply with all applicable requirements of the city's zoning ordinance.
That's really a catch-all. Says if we didn't specifically put it in here, we meant to. So I guess the question is, do we or do we not need R?
You'd be the first city that I've ever seen that's regulated pamphlets or billboards. I've never seen it in any ordinance in the entire state. And then you're running into exactly what he's talking about, constitutional problems with regulating content versus free speech.
And technically, the way that's written, if I'm listening to a podcast that happens to have an advertisement for a facility, and I'm listening to that while I'm trying to pick up my child from school,
Yeah, you violated the ordinance.
I'm in violation. Because it says in any form or any medium.
The state has rules on advertising for marijuana dispensaries.
So we should probably strike R from there.
Yep.
All right.
I'd like to have T brought into the zoning part of this, because that's kind of a catch-all. So whatever we've missed, it'll be taken care of with this.
Is that okay, Mr. Albright, moving T to the, where we're discussing zoning on these? Although it's,
Following you. I think T could just be left where it's at.
I thought we were moving stuff that pertained to zoning into the zoning section.
We were moving the sign section into the sign ordinance. But with
Okay.
regard to T, I think it's fine just where it's at, but that's
Oh,
just my opinion.
okay, even though that's under operational standards?
Yeah, I think it's fine.
Mr. Madigan, you have a comment?
Yes, sir. Laura had one last comment specifically for this subsection T at the end of it. With all applicable requirements of the city's zoning ordinance, and she would like to put a comma after that instead of a period, including special land use conditions and site plan conditions.
That's a good one.
Okay, could you repeat that?
At the end of the current sentence, replace the period with a comma, and it, including special land use conditions and site plan conditions.
And Mr. Albright says it's okay living where it's currently placed.
I'm satisfied.
Okay,
And by the way, this is a redundant statement, right?
Yeah.
Any company has to comply with all the city's zoning ordinances.
Yeah.
Like, I would just remove the statement. That's implied of being a business.
I would too, but I think, I take Walt's point that if by chance we, miss something or some detail, it's always good to have the catch-all language to comply with all other requirements of the zoning.
you know, like in the job description, the last ones, and all other related duties.
All other tasks as assigned, yeah.
Yep.
I like it better with Laura's additions.
Yeah,
I do too.
yeah, that's very smart. Okay.
So actually, everything from page 11 on is regulatory, which is something we kind of agree we don't.
Just hold 1 second, please. On page 20, number 2, it says washing hands thoroughly and adequate hand washing areas before starring. Could we put a T in there?
Yes, of course. That's just a typo.
Leave it to Walt to find it.
Surprised I missed that one. I have so many other circles on here.
So again, I'll ask on 10-233, assuming this is statute, do we want this in our ordinance? I don't.
Which one?
I would assume 10-233.
I think this gets back to the regulatory requirements and operational characteristics that Mr. Aiello, right? I'm sorry,
Yes.
has talked about before we
Kick
to-
it.
Yeah, kick it to
Okay.
council. Say,
Well, the city council may want to keep it in there, but
Yeah,
for purposes
right.
of planning commission review, the planning commission can just move forward to, at least page 21, and perhaps even to 23. Unless, the commissioners have any questions about any of that language. The planning commission's review may be complete at this point.
I'm good.
What would be the purpose of exempting it from the Freedom of Information Act?
sorry, where are you?
Oh. Like 23, subsection 5.
I'm sorry, what page? Page 23?
23.
Page 23.
Yeah, sub 5.
Oh, okay.
Okay, if we're asking for very specific information on financials like that, I could see where, to some degree, you want to respect the applicant's privacy.
So the state has a statute right on point that you're not allowed to take any of this information from state records, and I'm involved in some litigation in Lapeer involving this very issue. And the cities always do follow the state law too, that it's not foiable. There's so much private information inside of the applications. So what you should put in your ordinance is that you follow all state law regarding FOIA requests. It's not, you can't extract it from you either, because crafty attorneys will send a subpoena to a litigant, to a witness to produce these books, to the state, and then to the city. And so it's been about a 4-month fight in a circuit court with 5 different parties, not parties, but deponents that were asked to produce the book. And so this crafty attorney asked the cousin to give the book because he thought the cousin had a copy of it. He asked the state to give a book. He asked the city to give a book. So all of these attorneys had to come to court and fight this request. So one day in court, we had 5 attorneys fighting the request to divulge the information. The Lapeer Circuit Court judge denied the person's request to obtain this book from everybody. So you should put in there that it's not foiable.
And that's already in there.
Well, the question, it was in there, and the question that I believe Mr. Lalonde had is, why is it in there?
Because the state says so.
Good enough for me.
This would be the same.
Are you okay with that, Mr. Lalonde?
You sound disappointed, Leo. No? No? Okay. Just want to make sure.
This would be the same state that has done such a magnificent job delivering such a wonderful law to us.
So what are we going to do for the next 35 minutes?
Figure out what this motion looks like so we can get the heck out of here.
Well, I don't know we're at a point of making a motion yet, because I believe what needs to happen is that all these changes need to be incorporated into a document that we can review before we say, this is what we want to send to city council.
I have a proposed motion. A motion to instruct the city attorney in conjunction with the city planner to incorporate all of the changes or recommended changes made by the Planning Commission during the course of its review of the proposed medical marijuana facilities ordinance, and bring it back for the Planning Commission's review at its regularly scheduled meeting in March.
I'd like to make motion what he just said.
I was waiting for so moved.
Supported.
We have motion and support. Is there any other discussion?
No motion.
Walt.
Walt
Copied Rich.
said what Rich said.
Tim, you supported?
Yes.
And then Commissioner Palazzolo supported that. Is there any further discussion? Secretary, please call the roll.
Mr. Jakubiec?
Yes.
Mr. Palazzolo?
Yes.
Mr. DeHaan?
Yes.
Mr. Lalonde?
Yes.
Mr. Broll?
Yes.
Ms. Julinski, yes. Chairman Lubeck?
Yes. That brings us to the second hearing of the public. Mr. Aiello, did you have anything to add, since you're already up there?
Might as well. I mean, you're there.
We would like to thank you.
Anyone else wish to be heard? Anyone else wish to be heard? Seeing none, we will close the second hearing of the public. There is no new business tonight. Oh, I'm sorry, that was a public hearing, but, well, we did it as a hearing of the public. No new business. We're on to commissioners' comments. Ms. Ulinski?
I have none.
Mr. DeHaan?
Say nice things about our city. That's all I'm going to say. Say nice things about our city.
Mr. Palazzolo?
No comments.
Mr. Broll?
Nothing tonight.
Mr. Lalonde? Mr. Albright?
No comments at this time, Mr. Chairman.
Okay. Mr. Madigan?
I just want to let everyone know I talked to Laura today. She's doing really well, and she said she should be back at work next week. And thanks for having me. It was great to actually see you guys tonight. So.
Thank you.
Thanks.
Councilman DeMonico, did you have any comments?
Sure, just quickly, Mr. Lubeck, thanks everyone for talking about container homes at your last meeting and, you know, debating it very well and listening to all of the residents. And then also, just one informal thing about the container home proposal. Well, and thanks for moving forward with the medical marijuana ordinance tonight. Was nothing didn't need like a response today, but just, city administration was wondering if instead of two separate ones, it was just one container home that was larger than the minimum square footage. If anyone would be interested in something like that, there'd still have to be a variance on the exterior materials. But that being a potential project as opposed to the two separate container homes that are under the minimum.
How large are we talking?
Okay, this is not for discussion. This is just commissioner comments.
I don't know the.
We have the container issue that was tabled last month. It's going to be on our next agenda.
So, that's all, Mr. Lubeck. Thank you.
Okay, thank you, commissioners, for giving up an extra night this month to get this taken care of. There's a lot of other things we have to start moving on. A lot of things that were tabled at the last meeting because of the length that we can now move forward on because we've got this major issue soon to be behind us. And with that, I'll entertain a motion for adjournment.
Mr. Chair, I'd like to make a motion that we call it a day.
Second that?
Motion and by Mr. DeHaan, supported by Mr. Jakubiec. Secretary, please call the roll.
Mr. DeHaan?
Yes.
Mr. Jakubiec?
Yes.
Mr. Lalonde?
Yes.
Mr. Broll?
Yes.
Ms. Julinski, yes. Mr. Palazzolo?
Yes.
Chairman Lubeck?
Yes. Did I? I'm sorry.
What?
You didn't